No, okay. No worries. Unless it's today. We don't report anything, all we do is we're gonna tell the jail that we did see you in the neighbor housing recommendation, we don't have a release with the court, so that we Oh, okay, so that is just what we told you said, you report it, saying that you are worried about it, and then take it from there. You're also looking to report on your way back in, I just want to be doing do something more, but you don't want to. I got it. You don't want to do it? Willing to do it? This resource is gonna go over some of these grants, some resources locally. That's okay? Thank you very much.
We're on the record in docket 23-03661. People of the state of Michigan versus Carwin Cotton Martin. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Karen Robinson, Assistant Public Defender for Mr. Cotton Martin.
And sir, you are Carwin Cotton Martin, is that correct?
Yes, sir.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness is not here today. She was subpoenaed. If the court remembers, there was an adjournment previously because she was unable to attend. I expect a motion from the defense as the people cannot proceed without her today.
All right, Ms. Robinson.
Yes, we would make a motion to dismiss, Judge.
All right. Based on the motion to dismiss, and this being the second time for the complaining victim to fail to appear today, or with this, and they understood that they were to be here today, I will entertain and have the lost our court officer, didn't we?
Mr. Milks could grab it off
Okay.
the printer.
He grabs it off the printer.
Here you go.
We'll add that to your job description. All right. I'm in possession of the order of acquittal for docket 23-03661. In that this case is dismissed without prejudice, sir, which means the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right. All right. I will sign the order accordingly based on the defendant's the complaining witnesses failed to appear. And the case is dismissed without prejudice. Anything else on the record in docket 23-03661, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, you should be all set, Mr. Cotton Martin.
Thank you.
Thank you.
That's Jen. Oh, she's in board right now. Oh, yeah.
Or that's
Tanner.
not
Shaw. Yeah. Well, oh yeah, Palmer's here.
Mr. Palmer, are you ready on Mr. Shaw?
Yes, Judge. And this is just going to be a waiver of the timeline.
All right. So we're on the record in docket 24-01032. That's people of the state of Michigan versus Jacob Shaw. Ms. Smith, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith for the people.
Mr. Palmer.
Thank you and good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Jacob Shaw, the gentleman who's standing to my right.
And sir, you are Jacob Shaw, is that correct?
Yes, sir. Good morning.
All right, thank you. This is the time is set for a preliminary examination day. Ms. Smith, how are we proceeding?
Thank you, Your Honor. There are two necessary witnesses for this preliminary examination. Ingham County Sheriff's Deputy and U.S. Marshal TFO Ward, who was available for today, and Detective Trooper Haitala of the Michigan State Police, who was not available today due to being at an out-of-state training. Based on her unavailability and also defense's pending discovery request that was made on May 7th that we have not received back from the police department yet. The people and the defense are asking to adjourn this matter out a couple of weeks, and defendant is prepared to waive his 21-day timeline today.
And is that a fair statement, Mr. Palmer?
It's all accurate.
All right. May I inquire of your client of his waiver of the 21-day rule?
Of course.
Mr. Shaw, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Paul Palmer, and you would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding today it is your wish to waive your right to a prelim only within that 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period, because we have some conflicts and then more discovery coming in. So Mr. Palmer can zealously represent you in that preliminary examination. Is it your intent today to waive your right to a prelim within 21 days?
Yes, sir.
All right. And the people are a part of the adjournment, Ms. Smith.
Yes, Your Honor, we agree with this adjournment.
And you thought 2 weeks out?
I believe so, Your Honor. The discovery that is pending is body worn camera and in-car videos, which usually are quite quick. The only tricky part in this particular case is it's a multi-agency case. So requesting discovery from different agencies where they don't necessarily have their own case number has proved to be a little tricky, but I did have contact with somebody yesterday and they are working on it. So I think 2 weeks would be sufficient.
Is that in the wheelhouse, Mr. Palmer?
It is, Your Honor. I would say at least 2 weeks. As we speak right now, I'm scheduled to start a trial on Monday with Judge Dragonchuck. That seems to be falling apart as we speak, but nonetheless, I'm scheduled for it, and so I would not be available next week anyway.
All right, so we'll put it probably in the first couple of weeks of June, something like that. And then I don't know if and then you let us know if your trial schedule, because I know you've got more than one case coming up.
A lot.
Right.
Yes, but yes, that would be fine.
All right.
If the date doesn't work for Mr. Palmer, I'm happy to
Right.
We can
stipulate to adjourn and find a date.
we can figure it out, Judge.
June 7th at 8:30.
June 7th.
I'm off that day, Your Honor. I apologize.
All right, let's go 1 week. We go to the 13th,
8:30.
June 13th at 8:30?
Sure.
That works great. Thank you, Your Honor.
All right, Mr. Shaw, please keep in contact as best you can with your attorney. We've reset the preliminary examination for June 13th at 8:30. All right, sir?
Thank you, sir.
All right, anything else for the record? 24-01-032, Ms. Smith.
Nothing from the people. Thank
Mr.
you.
Palmer.
Nothing further.
All right, you're all set, Mr. Shaw.
Does he get a notice? Oh, right.
Yeah, you'll get it. You should get it printed
Legible.
right there. Drafted Mr. Milks from your office to.
We're unionizing too, Judge.
That one.
And we're ready to waive.
Thank you, Your Honor.
Thank you, Ms. Smith.
Yeah,
Okay, gotcha. Yep.
Makes sense. All right, yeah.
Ramirez.
It just wasn't the file, Judge.
Is that Shaw? And Mr. Paul, we lost our clerk though. I mean, that's Mr. Sheltonham's here for
Ramirez,
Premier.
Eddie Ramirez.
All right. Let's call that. All right, so we're on the record in docket 24-01-134. That's people of the state of Michigan versus Eddie Ramirez. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sheltonham.
Mike Sheltonham on behalf of the defendant, Your Honor, who's present, standing to my right.
And sir, you are Eddie Ramirez Jr., is that correct? Thank you. This is time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. The complaining witness in this matter is not present today. She was subpoenaed. Our office has had contact with her. However, it has not been fruitful, so I expect a motion from the defense.
Mr. Sheltonham.
Move to dismiss, Your Honor.
Thank you. So based on the complaining victim being subpoenaed and failed to appear, I will dismiss without prejudice. Mr. Ramirez, that means that the people could reissue if they choose to, as counsel probably explained, but for our purposes today, the case is dismissed. All right, sir?
Yes, sir.
All right. So based on the complaining victim failing to appear and proper service being made and some conversation with the complaining victim, the case of 24-01-134 is dismissed. Anything else for the record on that case, Ms. Wilson?
He's not untethered, is he?
He is
No,
not.
okay,
All
then
right.
nothing else.
Mr. Shelton.
No, thank you, Your Honor.
All right, Mr. Ramirez, you're all set. Thank you for your appearance today.
Nice to meet you.
Nice to- Thank
Good to see you,
Judge.
Mr. Sheldon.
Good to see you, Your Honor.
Does you want a copy of the Nolly, Mr. Shelton?
Yes, please.
Please, names can do that. And then we have Miss Ash whenever the court's ready.
All right.
I didn't.
That Mr. Milk's case.
No, that is Miss Schroeder, and she is right over
All
there.
right. Oh, I didn't even see Miss Schroeder over there. I lose.
She's the one that's been grabbing things for you.
I know, well, I thought,
Milks is
I thought Mr. Milks was getting all
Oh,
the,
he was doing
Mr.
this
Milks is getting all the
now.
glory.
Yeah, we all.
all-
knew about it.
all the glory that goes,
People's glory, yeah.
Mr. Mr. Paul.
He called me last.
All right, let's go on Miss Ash.
I'll let him know today that we- Probably just a sleep. I can touch base with him later today. Okay.
All right, so we're on the record in docket 23-02958. That is People of the State of Michigan versus Whitney Ash. Will the parties please introduce themselves for the record? Ms. Smith.
Abigail Wilson for the people.
Did I just call you Ms.
You
Smith?
did, that's all right.
Ms. Wilson. I have an excuse on some level. Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Miss Ash, who is present in the courtroom and standing to my left.
And ma'am, you are Whitney R. Ash, is that correct? All right, thank you. This is the time set for a sentencing today. I don't have a JOS. Have you had the opportunity to go through the pre-sentence report with your client, Ms. Schroeder?
I had the opportunity to go through it. I've discussed the recommendation this morning with Miss Ash due to her incarceration at the Eaton County Jail. She has declined at this time to go through it word for word with me, but she is in agreement with the recommendation.
So there's no additions, deletions, or corrections?
No, Your Honor.
Thank you. Is there any restitution in the matter, Ms. Wilson?
There is, Your Honor. It looks like Meyer is requesting $314.76 in restitution. The recommendation is for just time served, so I would just ask for that to be referred to collections.
All right. All right, allocution of Ms. Schroeder.
Thank you, Your Honor. As the prosecutor has alluded to a moment ago, the recommendation is for time served. We would join in that agreement for for the adoption of the recommendation and have the restitution sent to the collections department. Ms. Ash, as I think the court may be aware, there have been conversations, is going into the drug treatment court over in Eaton County with Judge Cunningham. I have been in consistent contact with her attorney over there, Daniel Sturdivant. I would note when this, on May 6th, when this was drafted, I believe she still had pending the matter. That is, I guess that would be count as a correction regarding the probation and circuit court at 30th Circuit for the possession of methamphetamine and stolen vehicle. That probation was terminated and she was discharged. Time served on that. I represented her on that matter and handled it with her for that hearing. With the idea, again, with the agreement that we were going to have Ms. Ash take care of her holds here so that she was freed up to participate in the specialty court in Eaton County. We would ask that the court allow for that to, similar to happen here with time served on this matter and refer to collections. Ms. Ash has been in custody for quite some time. on multiple matters, so I am not even sure about technically for the jail credit as to what would be the amount at this point.
Right.
But I would just ask for time served so that she can get, so I can make contact with her attorney over in Eaton County, and we can hopefully get a court date over there moved up so she gets started in that program. Thank you.
Thank you. Ms. Ash, is there anything you'd like to say to the court before the court passes sentence on this misdemeanor retail fraud? All right. Ms. Ash, you've had a long run, okay? Some of your history shows that. And so my advice to you is to use this as a resource. You now are as in a specialty court to use this to solve the underlying problem, which is not new to you. It's not new to me. It is an ongoing problem, and it's probably going to be one of the hardest things you do. Okay, you just have to be vigilant, because I'm not worried about you in the next 5 years. I'm worrying about you in the next 20 years. Every day is a thing. Okay, and that's what we're working on, and that's what we do. Okay, let district court help you. Okay, we don't help everybody at times, but I think we're going to provide a resource that can help you in this, and hopefully you can find a different path. All right. I'm going to follow the recommendation of the sentence recommendation in JOS. I'm going to waive fines and costs I'm going to assess the crime victim's rights fee of $75, state a minimum cost of $50 for a grand total along with the restitution. And I'll give you a total of that just so you know. For $439.76, and that'll all be referred to collections. I'm sentencing you to 93 days in jail, credits given for 93 previously served. And then the rest is referred to collections as indicated. Ms. Ash, you know the underlying problem. I know the underlying problem, so let's work on the underlying problem, okay? Anything else for the record in docket 2302958, Ms. Wilson?
Not for the people, thank you.
Ms. Schroeder.
Can we just note for the collections matter that she probably is going to either be in treatment or in jail for some time still, so I would ask that that be noted so that if she doesn't come right away, that they don't go to bench.
The order will indicate that she should contact the collections department within 48 hours of release, but I'll indicate that her release date will be out there.
Thank you, Nana. Nothing further.
Ms. Ash, good luck to you, okay? You're all set.
And this is the information regarding the collections, okay? All right, you take care, and I will reach out to Mr. Sugar.
Oh, thank you.
Thanks.
I believe Mr. Bush is ready. All right.
I gotcha.
Oh, is that the one I already had? Because we printed another one. Oh, that, yeah. I'll put them together and you can pick out the one that's not signed. We going on?
Bush, Deshaun Bush.
Sean Bush. How are you, Mr. Doyle?
Good morning, Alan.
Good morning. So we're on the record in docket 2401006. That is People of the State of Michigan versus Deshaun Bush. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Doyle.
Hey, please support Dan Doyle appearing on behalf of Mr. Bush, who's present and standing to my right.
And sir, you are Deshaun Bush, is that correct?
Yes, sir.
Thank you. This is the time set for a preliminary examination today Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe this is going to be a waiver of the exam that people also unconditionally waive. There is currently no offer at this time. Negotiations would need to be pursued in circuit court. However, defense has noted to me that they will be requesting HIDA and some kind of package deal with some other files. Whether or not that's what happens, I don't know, but I recognize that's what the defense is requesting.
All right, Mr. Doyle.
Yes, Your Honor, that's an accurate statement of what's going on today.
Okay, and negotiations are to continue in circuit court, is that correct?
That is correct.
All right. May I inquire of your client, Mr. Bush, of his waiver of the preliminary examination?
Yes,
All right, Mr. Bush, you understand you have a right to a preliminary examination today. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Dan Doyle, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to preliminary examination. That's an unconditional waiver. You'll go to circuit court and negotiations are going to continue in circuit court. Your time in district court will be done. Is it your intent today to waive your right to a preliminary examination? And Ms. Wilson, you are also waiving the people's right to a preliminary examination?
People unconditionally waive the right to an exam, Your Honor.
I find that the waiver of the preliminary examination be knowing, voluntarily, and accurately made. And I will have the documentation provided by my court officer or somebody to the like. Ms. Wilson,
Thank you.
for signature.
Your Honor, may I approach?
You may, Mr. Doyle. Thank you. All right, I'm in possession of the bind over documentation concerning Mr. Bush, been signed by all the parties. Before the court signs it, if there's anything else to be brought to the court's attention, Ms. Wilson.
Not for the people.
Mr. Doyle.
Oh, Your Honor, thank you.
All right, I will sign the documentation accordingly. Anything else for the record on 24-01-006, Ms. Wilson?
Not for the people.
Mr. Doyle.
No, Your Honor.
Okay, your time in district court is done, Mr. Bush. You'll get your next appearance date from your attorney, Mr. Doyle. Okay, sir?
Okay.
Okay, you're all set. Thank you for your appearance today. We got Mr. Milk still here.
Yep, and
Worried, are you just hanging out with us today?
Yeah. For the love of the game, Your
There
Honor.
for the love of the game?
Exactly.
Miss Wanji's on.
yes, she is covering for Mr. Silverthorne on the Panera matter. It's a Judge Buchanan case, I
Okay.
believe. That's a competency. And he was on Polycom. Oh, and Mr. Nagel is there as well.
Okay. Oh, he was with Miss Wanji, yeah.
Yeah.
That was on the tablet.
They're ready to go on that though.
All right.
I was just saying, not if I had to, I have to went for change.
Right, so we're on the record in docket 24-00882. That's People of the State of Michigan versus Travis Panera. Will the parties please introduce themselves to the record? Mr. Nagel.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Melanie
And ma'am, you are Melanie Wanchi, is that correct? I couldn't hear you.
Yes, Melanie Wanchi from the Public Defender Office, Your Honor. I'm sitting for Mr.
You're still breaking up a bit, Ms. Wanji.
Melanie Wanchi from the Public Defender Office, and I'm sitting here for Mr. Silverton.
All right. And sir, you are Travis Panera, is that correct?
Yes, sir.
All right, you can hear me, Mr. Panera?
Yes, sir.
Thank you. This is the time set for a competency review hearing. Mr. Nagel, how are we proceeding today?
Your Honor, I've had a chance to review the report from the Forensic Center. We will adopt the recommendations in the Forensic Center. It's my understanding that Mr. Panera has been found incompetent to stand trial at this time, but the forensic examiner believes that he can be found competent at a date in accordance with the statute.
All right. And Ms. Wanji, is that your understanding?
It is my understanding also, Your Honor. So we're going to adopt the report.
All right. So based on the statements made by the party, the court will find the defendant is incompetent to stand trial but restorable pursuant to the report. And then we should set this. Mr. Nagel, how many days should we? I'd like this set for review just so we don't lose track of it. I know there's some time frame associated with the with having the defendant restorable. How far out were you looking for a review hearing?
Your Honor, maybe we can set one out for 30 days.
All right. Ms. Wanji, is that fair 30-day review hearing?
That's fine, Your Honor.
All right. So let me find a date for you. All right, it'll be set for June 20th at 9:30 in front of Judge Buchanan. I will sign the document for incompetent stand trial but restorable. And then you can revisit this with Judge Buchanan on June 20th at 9:30. Anything else for the record in 24-00882, Ms. Wanji?
No, Your Honor, thank you.
Nothing from the people.
All right, you're all set. This will be reviewed by Judge Buchanan on June 20th. Thank you for your appearance today.
Thank you, Your Honor.
So, Mr. Panera, you're all set. You can tell them that you're all set, okay?
Thank you.
Thank you. How are you, Ms. Wilson?
I'm doing all right. So I think we have two that are ready. One is Mr. Pena. I have an officer here that is an exam that's going to run.
Okay.
I would like to get that one done sooner because I believe my officer is also supposed to come back later this afternoon, and I'd like to give him a bit of a break before he has to come back.
All right.
The other is Linguidi, which this law just stepped out. That one is going to be a closed courtroom case. Okay. Oh, okay, never mind. Well, that one would also be ready, but it appears it's gonna be a waiver.
Okay, so Linguini is a waiver, and so if we can do the waiver, then we'll start the prelim.
Yeah, that's fine. I believe he's in custody.
That's different then. So let's get Linguini. And then I'll leave it up. Do you want to start or do?
I think we can start it. It should be fairly quick.
All right.
If Mr. Milks is ready.
You ready on
Pena?
Mr. Pena?
Yes.
Okay.
Yes.
Well, let's go ahead and go on Pena.
All right.
Yeah. All right, so my understanding is that we can't isolate mics at this point, so be as loud as possible.
Okay,
And just so, because we can't, so we might want to turn off the fan.
probably.
Yeah, let's turn off that. Let's see how, that beats changing courtrooms.
Still trying to fix it, but at least we got it.
Yeah. Turn it off.
All right. All right, so we're on the record in docket 24-01034. That is people of the state of Michigan versus Santiago Pena. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Mills.
Yeah, good morning, Your Honor. Stephen Milks on behalf of Mr. Pena, who is present and seated to my right.
And sir, you are Santiago Pena, is that correct?
Sir.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we are ready to start the exam.
All right. Are there any preliminary matters to come to the court's attention before we get started, Ms. Wilson?
I believe there's going to be a general sequestration order. I do have one witness here today. He is an officer. He's currently in the jury room.
All right. And Mr. Milks, anything besides the sequestration order for the court to consider in this matter?
No, not preliminarily, Your Honor.
All right. So I'm going to leave it to counsel. If you see anybody, you know the case better than I do. If you see anybody in back that you don't believe should be a part of sequestration or shouldn't be a part of watching another witness testify, let me know and we'll invoke the sequestration order. Somebody also could come in. With that understanding, Ms. Wilson, you may call your first witness.
Thank you, Your Honor. The people called Jamil Bafri.
Right, Officer Backer, I'm gonna have you come right up here. I'm gonna have you stand right in front of me and please state and spell your first name and your last name for the record.
It's Jamal Bakri. Spelling is JNBIL. Last name is BAKRI.
Okay. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, then have a seat. I would project as loudly as we can because we don't know what mics are working, so just project to the back of the room, all right, sir?
Yes, sir.
All right. Ms. Wilson, when you're ready, you may proceed.
Thank you, Your Honor. Officer Backery, are you currently employed?
I am.
Where are you employed?
City of Lansing,
And what's your job title?
patrol officer.
And what are your general responsibilities?
To answer calls that come in through dispatch.
And were you working or were you in the same position back in October of 2023?
I was.
Okay. How long have you been a police officer?
Now 5 years.
5 years. And during your time as an officer, have you received any special training in relation to controlled substances?
Yes.
And what did that look like?
I received training in regards to identifying what substances are, as well in the academy, as well as my experience dealing with it on the road.
Okay. And in your experience dealing on the road, have you encountered a significant number of drug cases?
Yes.
Okay. And have any of those involved delivering narcotics?
Yes.
Okay. Now, back on October 25th of 2023, were you working as a police officer?
Sorry.
Back on October 5th of 2023, were you working as a police officer?
Yes, I was.
And on that date, were you dispatched to 1102 South Grand Ave?
Yes,
Is that in Lansing,
yes, it is.
Ingham County,
Yes,
Michigan?
Yep.
And what was that call in reference to?
that was in reference to a break-in and entry.
And when you arrived, what was happening?
So the original dispatch information was that there was an ex that was breaking into the house and that subject was leaving in a silver Pontiac G6. So upon arrival, I saw a Pontiac G6 in the driveway.
Okay, and was there anybody there?
Inside of the vehicle, there were two subjects.
Okay, did you make contact with any of them?
I did.
Who did you make contact with?
I made contact with the defendant as well as a passenger that was in the vehicle with him.
So the other individual that you identified as the defendant, that was the driver?
Yes,
Okay, and during your interaction with him, did you get some sort of identification from him?
I did.
And what was that identification?
Santiago Pena.
And during your interaction with him, did you get a good look at him?
I did.
Do you see him here in the courtroom today?
I did.
Can you point him out and describe something he's wearing?
He's wearing a white t-shirt with a cross necklace.
Thank you. Your Honor, for the record, I just request that reflect identification.
Any objection to the witness identifying the defendant for purposes of prelim, Mr. Mills?
Not for purposes of prelim, Your Honor.
Thank you. With that understanding, the witness has identified the defendant.
Thank you, Your Honor. So after you approached the driver, Mr. Pena, what happened?
So I didn't approach him. I called him back
Okay.
to me, just based off of the nature of the call and not having a full understanding what was happening yet. That was common procedure when someone gets out of the car, which he did once I pulled up. So upon taking him into custody, I detained him just because, again, that was the very preliminary stages of that call. And he was out there when I first pulled up.
Okay, and when you detained him, what happened?
I placed him in handcuffs that were checked for tightness. And then I brought him to the back of my patrol vehicle. And at that point in time, I conducted a Terry pat just based on the call that the subject may have been trying to break into a house. I know that from my experience that those subjects can sometimes carry tools to allow them to break into houses. So just make sure there wasn't any deadly weapons or dangerous weapons on him at that time.
Okay, and in your patting him down, what happened?
So while I was conducting my Terry pat, we usually start with the waistband first, simply because that's where a lot of dangerous weapons can be held. While I was doing that, the defendant appeared to be trying to grab the right side of his sweatshirt pocket. He's wearing a zip-up sweatshirt that was unzipped fully at that time. The first time he did it, I just kind of moved the sweatshirt away from his hands. He then did it a second time, in which case I advised him to stop reaching for his pocket. I conducted my pat and then ultimately got to the position where I would now be checking patting the outside of the pocket on that side. I could see that there was a digital scale that was now partly just hanging out of the pocket due to when he was grabbing the sweatshirt and just kind of manipulating the sweatshirt, the end of it kind of popped out of the pocket. And also with feeling the outside of it, I could feel that it was a bulky object that was also in that pocket. I could feel a softer object that was, in my experience, consistent with a powdery narcotic.
Okay, and once you felt that, what happened?
I advised Mr. Pena to not try to grab for his sweatshirt when I'm trying to make sure he doesn't have dangerous weapons. And I also advised him that I knew that there was narcotics in his pocket.
And did he say anything to you at that time?
He advised that he was sorry for trying to grab the pocket. And he also advised that that was not his sweatshirt and that it belonged to his cousin.
Okay, and did, after you informed him of this, what happened?
Upon informing him of this, Officer Fox came up on my right and he actually went into the pockets for me. He had gloves and I didn't, and removed those.
Objection, Your Honor. At this point, this is something that the officer did not do. I think it also would be based on hearsay that the search is being conducted by another individual at this point.
Your Honor, if I may, I believe Officer Backery observed Officer Fox take it out of the pocket, which would not be hearsay. It's not some kind of assertion. It's an action that happened, and he can testify to what he saw.
Right now, I just see him as a witness observing. I don't think anything's been said to him. If anything is said to him, that would turn into a hearsay statement. But right now, he's a mere witness. So I'll overrule the objection.
May I have one voir dire question, Your Honor? Was this search conducted by a warrant?
No.
Okay, thank you, Your Honor.
Yeah, my understanding right now, we're still in the progression of a Terry type of.
That is correct.
Stop. Okay,
Yes.
Thank you.
So Officer Fox is taking items out of his sweatshirt, is that correct?
Correct.
And did you actually observe Officer Fox taking the items out?
Yes.
And what did you observe him take out?
I observed him remove the digital scale as well as a plastic bag that contained a white powder substance that I believe to be powder cocaine.
Okay, and after that happened, what happened?
After that, he was placed in a patrol vehicle, and I attempted to read him his rights so that I could ask him further questions about it, because he had stated that he that it wasn't his sweatshirt. However, I read them twice to him, and he never answered that. He never answered it whether or not he would answer my question. He just continued repeating that that it wasn't his sweatshirt and it wasn't his. So ultimately, I wasn't able to ask those questions.
Okay, and after that, did you do anything else?
I personally did not do anything. I helped with the search of the vehicle briefly, but I didn't.
Was anything found in the vehicle?
Yes, Officer Fox located.
Objection, Your Honor. This now he's speaking without having personal knowledge of this, or at least he's setting up the foundation that someone else found these objects. That's not been proper foundation laid as to whether or not
All right,
he observed this.
With the so is this something he saw or heard?
I believe it's something he saw. I can ask a follow-up question.
All right, if it's something you saw, he can testify. If it's something Officer Fox told him, then we're back in our hearsay problem.
Okay.
Thank you, Your Honor.
And Officer Backery, did you see Officer Fox take anything out of the car?
I did not.
You did not? Okay. With that understanding, Your Honor, oh wait, no, I have more questions. So the substances that you took from Mr. Pena's pocket, was the powdery substance ever tested?
Yes.
And who conducted that test?
I did.
And how was that conducted?
Using the TrueNarc system.
Okay, and are you trained in the TrueNarc system?
Yes.
And what procedure did you use to test it?
So in order to use the TrueNarc, you have to first test it to make sure that it is working properly. Upon getting the pass that it was working properly, I placed the object in another plastic bag in which the laser reads the substance, which it returned that it was cocaine. And then I conducted another test afterwards to make sure that the TrueNarc was still working.
And it wasn't still working?
Yes,
Okay, and at a point, did you weigh the substance?
I did.
And what was the result of that?
Approximately 8 grams with the packaging.
And what kind of packaging was it in?
Plastic clear.
And do you know approximately what that packaging would weigh?
I don't.
Would you say it's
Objection, Your Honor.
feeling the plastic?
So the objection, what's the nature of your objection?
Nature of my objection, Your Honor, this is going to be a leading question. I think it's pretty clear she's trying to elicit testimony that he's already said he's not.
I'll let you rephrase. Objection sustained.
Was the packaging thick?
No.
So it was a thin plastic bag. Based on your training and experience, if the substance wasn't in there, would that have a significant weight?
And I'm going to object here, Your Honor. As she is trying to elicit opinion testimony, he's not been qualified as an expert. And if she moves to qualify him as an expert, I request a opportunity to voir dire the witness regarding his expertise in whatever area she seeks.
Thank you. Response.
Thank you, Your Honor. I don't think it's an expert testimony. It's a testimony based on his knowledge and experience and him feeling the actual plastic bag. So I don't think this needs to be an expert statement. I think Officer Backery has personal knowledge of the plastic baggie and he can testify to it.
I agree with Ms. Wilson. I find he has 5 years experience. It's not expert testimony in the sense that he's identifying. He's just basing it based on his 5 years experience as to the weight or lack of weight of what the item's been stored in. With that understanding, I'll overrule the objection.
Thank you, Your Honor. So Officer Beckery, do you need me to rephrase the question?
Yes, please.
So based on your training and experience, without the substance in that baggie, what would the weight of that baggie be significant?
It would not.
Okay, nothing further, Your Honor.
Cross-examination, Mr. Mills.
No, Your Honor, no cross-examination. Thank you.
Without any cross-examination of the witness, that would suffice to redirect. May this witness be excused, Ms. Wilson?
He may, Your Honor.
Mr. Mills?
Yes, Your Honor. Thank you.
All right, thank you for your appearance today. You're all set. Any further witnesses, Ms. Wilson?
No, Your Honor, thank you.
Do the people rest?
We do, Your Honor.
Any witnesses today, Mr. Mills?
No, thank you, Your Honor.
Motion for bind over, Ms. Wilson.
Thank you, Your Honor. Today you heard testimony from Officer Beckery that on October 5th of 2023, he did make a respond to a call at 1102 South Grand Avenue. He said that was in the city of Lansing, Ingham County, state of Michigan. He said on that date, he approached somebody who was later identified as Mr. Pena, who he then identified here in the courtroom today. He found 8 grams of cocaine in his pocket, as well as a digital scale. Mr. Pena is currently charged with controlled substance delivering and manufacturing of cocaine, heroin, or another narcotic less than 50 grams. And it's currently charged under a theory that he did possess with the intent to deliver less than 50 grams. Based on the testimony here today with the scale and the cocaine that was found, I think there's a reasonable inference that he was intending to deliver that cocaine to someone else. So, if I also would state that his intent there is probably a matter of fact for the jury to conclude. So I would request bind over as charged.
Okay, just to clarify for my, this was not done subject to search instance to arrest or a warrant. This was done as a Terry pat down that led to the finding of the evidence.
It was done initially as a Terry pat down. As Officer Beckery testified, he was concerned that based on the nature of the call, that there was some kind of dangerous weapon that could be used to harm him. And in the course of that Terry pat down, he identified objects that he believed to be contraband, and he conducted a probable cause search based on that information.
And he actually, my understanding is he actually indicated he observed the digital scale.
That is correct.
All right. With that clarification, for the court's purposes, response, Mr. Milks.
Thank you, Your Honor. Your Honor, at this time, we fully understand that the people have definitely shown that there's a possession at this point. I don't think that's going to be a question. At a minimum, that's definitely a question for a jury to decide. In this matter, though, there has been zero testimony regarding delivery manufacturer. The courts have routinely discussed the fact that these are innocuous objects, such as a scale, cannot in and of itself be indicative of delivery manufacturer. There's no other evidence to show that this was delivery manufacturer. For example, there were not large amounts of cash that were found. There were not individual baggies that were found. There were no razor blades, no lighters to my understanding and knowledge. There's been no testimony regarding, like I said, pre-measured bags or anything regarding those lines, large quantities of drugs on my client's individual. This is 8 grams. A gram is the head of a pencil eraser. There were 8 of those. The people are really stretching it to say that this is purely indicative of delivery manufacturer. It's absolutely ridiculous at this point, Your Honor. I do agree that it should be bound over probably on a possession charge, but this court has no basis. Even the officer said that based on his training and experience, he made no opinion based on his training and experience regarding what this was indicative of, what the scale meant to him, whether the scale was even tested, whether it was even involved in this matter. There is absolutely nothing here, Your Honor. And I do think it is a huge stretch for the court to try to find, even based on an inference, based on the lack of testimony, that this is delivery manufacturer under 50 grams. Thank you, Your Honor.
Thank you. Response, Ms. Wilson.
Thank you, Your Honor. I think the fact that the scale was found in conjunction with the cocaine is sufficient probable cause. This is a rather low standard here today. So I would request that the court bind over as charged. If the court's not inclined to bind over as charged, I would request a bind over under possession.
Thank you. This is the lower standard, it's a probable cause standard. That probable cause being the second lowest standard, reasonable suspicion being less. There is some conflict or there's some concerning the case law concerning Terry, but it would appear that based on the location, venue, ID, and date have all been met at a probable cause level. So really the elements of the crime are at issue here. And it's the possession with intent to deliver. Did he knowingly possess? I believe that that's been established by the facts in the matter. The the question is, did he contain the controlled substance with the intent to deliver? And there's plenty of case law on this topic issue. I think the case law cuts both ways. However, there is some weight here. It's 8 grams of cocaine. 8 grams does not appear to be. It is the size of a fingernail, but 8 fingernails is big and is bigger in the world of cocaine than it is in the world of pot or some other substance, depending. So we have 8 grams of cocaine at measurable. But what we also have is a digital scale that is part of and so proximity becomes an issue. Proximity concerning the digital scale. There was no, I didn't find any evidence, nor would I need to find that there was a plausible reason for the scale next to the cocaine. The cocaine was tested. It is true narc tested by the officer. So at the lower schedule, at the lower level, I find there's probable cause evidence to believe that the elements of the crime as charged, which is possession with intent to deliver less than 50 grams of mixture containing the controlled substance of cocaine. The intent to deliver, which really is at issue, is the amount of cocaine, which is more than personal use or could be as indicated personal use, and then the scale, which led to the possible possession with intent to deliver, which scales are traditionally what is looked for along with packaging and money and things of that nature for the mens rea for intent. I believe that's been proven at a probable cause level. So with that understanding, I will bind over as charged.
Your Honor, with all due respect, Your Honor, I would just object that I think the court's findings here regarding an opinion on personal use and an opinion regarding packaging and the scale itself, I think is outside the facts that were entered here. I'm just noting my objection for the record.
Thank you, Mr. Wilkes. So it's bind over on charge is count 1 as charged. Count 1, which is the possession with intent to delivery less than 50. I will. So the examination was held on today's date. So the defendant is bound over as charged on count 1. Prior to me signing the bind over documentation, anything else for the record in docket 2401034, Ms. Wilson?
After people.
Mr. Mills?
No, thank you, Your Honor.
All right, with that understanding, Mr. Pena, your time in district court is done. You're on to circuit court where that is the trial court. This is a probable cause hearing. And I will sign the document that this is bound over as charged. You'll get your next date from Mr. Milks in circuit court, which is the trial court, okay? All right. All right, anything, is that all? That's all for the record, 2401034. Thank you, everybody, for your appearance.
Thank you, Your Honor.
Oh, I didn't even see when he was going. How about that? Lost my court. All right, so we're on the record in docket 24-00199. That is people of the state of Michigan versus Matthew Linguidi. Will the parties please introduce themselves for the record? Ms. Lawton.
Good morning, Your Honor. Jennifer Lawton on behalf of the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Linguidi is present. He is present with me at council table.
And sir, you are Matthew Linguidi, is that correct?
Correct.
Thank you. This is the time set for a preliminary examination. Ms. Lawton, how we proceed?
It's my understanding that the defendant will be unconditionally waiving his right to the preliminary exam. People also unconditionally waive their right to preliminary exam. Negotiations will continue in circuit court.
And is that a fair statement, Mr. Austin?
It is, Your Honor. My understanding it would be bound over as charged. Negotiations would continue at the circuit court level.
May I inquire of your client, Mr. Linguidi, of his waiver of the preliminary examination?
Yes, you may.
All right, Mr. Linguidi, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Brian Austin from the Public Defender's Office. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right in district court to a preliminary examination, have negotiations continue in circuit court where this case would proceed. Is it your intent today to waive your right to a preliminary examination?
Yes, Your Honor.
All right. And Ms. Lawton, as you've already indicated, the people are also waiving their right to a prelim. Is that correct?
That's correct.
Okay. I find the waiver of the prelim to be knowing, voluntarily, and accurately made. With negotiations to continue, I will have the parties sign the bind over documentation.
No, there is.
Depends on if it's the new one or the old one.
I know.
All right, I'm in possession of the bind over documentation in 24-00199, signed by both parties. Is there anything else to come to the court's attention before the court signs this, Ms. Lawton?
Nothing from the people.
Mr. Austin.
Yes, Your Honor, if I may address the issue of bond, please.
You may.
Thank you, Your Honor. Mr. Linguidi's bond, I believe, is currently set at $250,000 cash surety. That is obviously a bond that he is not and would not ever be able to post. It is my understanding and belief that Mr. Linguidi does not have any prior criminal history of any kind. He was living and working here most of his life with ties to the community, and he would be residing somewhere here upon release. I think there would be sufficient safeguards. I think a GPS tether is attached as part of his bond conditions. It would be sufficient safeguards to provide for either the safety of the community or the complaining witnesses in this case. Also, and just preemptively, Your Honor, I'm anticipating what the people's response largely is going to be to that is that Mr. Linguidi was picked up in Florida and had to be brought back here, and it is their belief that he was doing so to evade prosecution. But I do not believe there are facts sufficient to support that. Mr. Linguidi found himself here out of work, and he merely went there to seek other job opportunities. So I don't think that there is sufficient facts to support that he was going there in some type of an attempt to evade or flee from prosecution. And again, I would reiterate that he has no prior criminal history of any kind as far as I'm aware. I would ask the court to take that into consideration and grant him some type of relief in either the form or the amount of his bond. Thank you.
Thank you. Ms. Lawton.
Thank you, Your Honor. A couple of things. One, I think that the nature of these charges alone are sufficient for the bond to stay as they are. He's charged with 5 counts of criminal sexual conduct in the first degree, involving a person under the age of 13, child abuse in the first degree, and interfering with a crime report. These are incredibly serious charges, and I do believe that the safety of the community would be affected. Also, to Mr. Austin's point, yes, Mr. Linguini did flee the state. He did have to be extradited from Florida. He did take steps to make his leaving, I think, more permanent, including potentially selling a vehicle before he left the state. So I do think that he is definitely a flight risk at this point. I would ask that the bond remain as is.
Thank you. I do have a bond recommendation report that was filed by the prosecutor's office in this case. I understand the nature of the bond reduction, however, based on representations of counsel, but this is a 6th count life offense against a child, and there's indication that the defendant was found out of state. I'm going to deny the motion to reduce bond. And sign the bind over accordingly.
Thank you.
All right, so Mr. Linguini, you'll get your next date in court from your attorney, Mr. Austin. That'll be in circuit court, where the trial court where this is to continue. And that's all for the record in 24-00199. Thank you, everybody, for your appearance.
Thank you.
Thank you, Judge.
Thank you, Mr. Austin. Thank you, Mr. Austin.
Thank you, Judge.
Ms. Wilson, who's next?
We have Mr. Thompson here.
Oh, who do we have?
Mr. Thompson?
Mr. Thompson. You're on that one, Ms. Lawton.
I am.
Okay. All right, so we're on the record in docket 24-00886. That's people of the state of Michigan versus Calvin Thompson. Will the parties please introduce themselves for the record? Ms. Lawton.
Good morning, Your Honor. Jennifer Lawton on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. and I just blanked on his name, Thompson.
And sir, you are Calvin Thompson, is that correct?
Yes, sir.
Thank you. This is the time set for a preliminary examination day. Ms. Lawton, how are we proceeding?
Your Honor, it's my understanding that the defense will be requesting an adjournment in this matter. Do people have no objection to that? We had a probable cause conference last week with Judge Simmons, at which time we asked her to sign a protective order to release some additional discovery. For some reason, it slipped by both Ms. Robinson and myself that we didn't actually get a copy of that order. And so the discovery did not go out to Ms. Robinson until late yesterday. So it's my understanding she needs some additional time to review that. She and I are also working further on some negotiations on this case.
All right, so it's a request for an adjournment for discovery purposes, is that correct?
That's correct.
That's correct.
All right, and it is, I don't see here where the defendant Mr. Thompson has waived his 21-day rule, although there was a previous fail to appear. What are we doing about that, Ms. Lawton?
I will defer to Ms. Robinson.
Ms. Robinson.
Yes, Your Honor. I believe the failure to appear, is the waiver under the 21-day rules, but he'd be willing to waive his rights again, I guess.
Let's just do it in general, just so we have it. And then we'll get a new date. What are we looking at? Looking at as far as 2 weeks? All right. May I inquire your client of his waiver of the 21-day rule, Ms. Robinson?
Yes.
Mr. Thompson, you understand you have a right to a prelim within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing. That's what we're here for today, to see if there's probable cause evidence that a crime's been committed and the identity of the person who committed that crime. You are represented today by attorney Erin Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. If you waive your right to a prelim within 21 days, you'd just be waiving that right. You wouldn't be waiving your right to a prelim in general, just within that 21-day period. There's been some previous failed to appear, so this is kind of a belt and suspenders approach. But is it your wish today to waive your right to a preliminary examination within 21 days of your date of arraignment so that you can get more discovery, so that your counsel, Ms. Robinson, will be adequately prepared to zealously represent you, okay? Is that your wish to waive your right to a prelim within 21 days? All right. I'm going to find a waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset prelim for, does June 7th at 8:30 work?
Yes, Your Honor.
Ms. Robinson?
Yes.
The June 7th at 8:30. So we've adjourned this matter to June 7th at 8:30 for additional discovery purposes. Anything else for the record in 2400886, Ms. Lott?
Nothing else from the people.
Ms. Robinson?
No, Your Honor.
All right, we'll see you on that June 7th date. Thank you so much.
1 second. Yeah, notice.
We'll do it better.
Stanley, do we have to bring up Mr. Smith?
Yes.
He's gonna be waiving the
Okay.
timeline.
But he was waiving the exam.
Well, we don't want him to find.
Okay,
We don't
that's
find him
fine.
yet.
Yep.
But I do want to set, we don't really have to set.
Yeah, if you can get him and
That's what you don't have to appear.
tell them we're getting one for the other.
Yeah. Nice to see you, Judge.
Thank you, Ms. Lawton. We'll see you. What about you, Mr. Mills?
Come on now. I mean, I did the same thing, Mr. Mills.
Thank you.
Isn't it?
Yeah.
Can you see if Dominic Good, yes.
Ms. Wilson, you had a lot going on today.
We do, yes. I think if we want to do Palmetier.
We can wait if
Wait.
there are other things. I'm waiting for
Alright.
him anyways.
Yeah.
Okay.
Yeah.
Able to track,
Okay.
leave a message.
I asked him to, I don't think he heard me, he didn't say anything back, but that sometimes that means.
So, Mr. Willis is here. He is unrepresented.
All right, let's talk to Mr. Willis today. All right, Mr. Willis, you can come up here. Yes, sir. So we're on the record in docket 2401249. That's people of the state of Michigan versus LaKendrick Willis. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson.
Mr. Willis.
Willis.
Thank you. This is time set for a preliminary examination today. And Mr. Willis, today you are without counsel, is that correct?
Well, I have counsel, but he.
Not here.
Yes, sir.
Okay, and that's my understanding. You've declined court appointed, but you have retained Mr. Mataloni, is that
Yes,
correct?
yes,
Okay.
Your Honor.
And do you know if Mr. Mataloni has filed an appearance?
I haven't received one.
All right.
I spoke with him this morning. I thought when I had my Zoom meeting that you guys, because it was with the judge that came peeked in the door.
Judge Simmons.
Yes,
Okay.
so I thought they would go, because once I said who he was, she was like, okay, we know who he is.
Yeah, I know Mr. Mataloni. I've known him for years. What the court waits for is an appearance so that we can file out, so we can send out. So that's the trigger to send out the police report to the person who's representing you. But if that just happened recently, what I'm in a position to do is to.
I think that adjourning this probably for good cause
For good
is
cause,
fine. I
I
will
agree.
note that Mr. Willis said at the PCC that he had paid Mr. Mataloni last week. So I'm not really sure why Mr. Mataloni hasn't filed an appearance and why he's not here today.
Right.
So I think if there's not an attorney next time, we need to move forward.
I agree. I couldn't agree with you more. Mr. Willis, we're all entitled to one to one adjournment based on Mr. Mataloni not filing an appearance or just the urgency that comes in the next week. So what we're going to do is we'll adjourn for good cause.
Appreciate you. Thank you.
This will be a good cause adjournment.
I spoke with him this morning as well, so it was just short notice.
Right. Just make sure he files an appearance because that's when he gets all the discovery, okay?
Yes, sir.
So we'll adjourn for good cause based on new attorney and a couple weeks out. That's probably 3 to be safe. Yeah,
Yeah, that'd be good.
June 7th at 9.
So we'll reset for June 7th at 9 o'clock. And then Mr. Mataloni will get all the discovery once he gets his appearance in. That'll be set for June 7th at 9 a.m. Anything else for the record in 2401-249, Ms. Wilson?
Not for the people.
Mr. Wilson, do you have any questions of me?
No, Your Honor, thanks.
Okay, you should be all set. Thank you for your appearance.
All right, have a good one, man.
You too.
Oh, sir.
Mr. Willis, we have a notice for you. Just a moment, please.
We'll give you notice,
You need written notice.
just a written notice.
One job.
You're falling asleep, man.
One job.
Wow.
Wow.
Wow. That was all 3 jumped right on.
I know. You see what I feel?
I see that you're either really well liked or not liked at all.
Blood in the water.
I would
Sharks.
I would venture you're pretty well liked.
That's one word for it.
Yeah.
Even your best
Sorry, that
friend
laugh was a
shaking
little
his head.
That's more volume regulation.
That's fair.
Listen, I'm one who yells out.
I think we're ready on Samuel Wilson whenever the court is.
All right. All right, so we're on the record in docket 23-00303. That's people of the state of Michigan versus Samuel Wilson. Will the parties please introduce themselves for the record? Miss Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Wilson.
And sir, you are Samuel Wilson, is that correct?
Yes.
Thank you. This is the time set for preliminary examination. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that Mr. Wilson intends to accept our offer, and our offer is that he plead to a use on this file and then plead to one of his other misdemeanor domestic violence files, and he can take a stick on that one.
Okay.
And then the second domestic violence file will be dismissed.
So there's 2 files, and he'd plead to the 1-year use of cocaine and then one of the other domestic misdemeanors.
Yes.
You want to do it all right now?
I think that would be
Yeah,
probably best.
Let's grab it. So
I
let's
know our
take,
Monday's looking
let's
busy.
take 5 or 10 minutes and
Yep.
let's grab them all and do
Okay.
it all here. So yeah, so let's take 5 minutes, let's grab the other files and let's do it all now.
Do we want to
Sounds
do
good. Yeah.
Mr. Smith while
Sure.
we're waiting?
But we wait for which, If I
Oh,
start
that's
without
true.
Wendy,
Yeah.
Oh, yeah. when-
I'll
Yes.
hear it. Okay, I will hear it.
Is Kelly around?
Yeah.
Or you did, okay, all right. Nick, okay.
Do not start with your absence.
Hey, sorry, I missed you. Just reminded you, of course.
All right, let's go on Wilson. I think we're ready on Wilson. All right, so we're back on the record in docket 23-00303. My understanding of the plea agreement as indicated on the record by counsel, we have the other two files. Ms. Robinson is a plea to, this would be an
Added count two.
An added count two of use of cocaine,
Methamphetamine.
use of methamphetamine. Thank you. And do you have a PAC code for that?
I do. It's 333.74042 A-A.
That's 1 year.
1 year and or 2000.
And then also to pick one of the domestic violence files, and we'll do that second.
Yeah.
Okay. Is that your understanding, Ms. Robinson?
It is.
All right. May I inquire of your client of his advice of rights on the 1 year misdemeanor plea?
You may.
Mr. Wilson, you understand that this is punishable by 1 year and or $2,000, this misdemeanor plea. Do you understand that, sir? Yes. All right. I'm gonna give you the following advice of rights in this misdemeanor plea. I'll walk you through those rights. All right. You have the right to be tried by a jury, to be presumed innocent until proven guilty. You have the prosecutor prove beyond a reasonable doubt that you are guilty. To have witnesses against you appear at trial. To question any witnesses that are brought against you. You are represented today by Attorney Aaron Robinson. Should be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir? Yes. You have the right to have the court order any witnesses appear in your defense, remain silent during the trial, not to have that silence used not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what's been stated on the record, which is a plea to the use and then one of the other DV files. Everything else is to be dismissed, or threats that it was not your choice to plead guilty. And you'd be giving up the right to a trial, to appeal anything from trial. Since you won't be having a trial, you'll be pleading the added count two of use of cocaine in this file. Is it your wish today to plead guilty to the use of cocaine in this file?
Methamphetamine.
Methamphetamine in this file. Okay. Let me bring your attention back to August 23rd, 2022 at the offense location of East Miller, South Pennsylvania in the city of Lansing. Were you present in the city of Lansing on East Miller in South Pennsylvania on August 23rd, 2022?
Yes.
And at that time, did you use the substance of methamphetamine at that date and time?
Yes.
And you knew it was methamphetamine when you were using it?
I didn't, but I knew what it was.
You knew what it was? All right. Anything towards the factual basis, Ms. Wilson?
None for the people here.
Ms. Robinson?
No, Your Honor.
Yeah, I find the factual basis to be knowing, voluntarily, and accurately made. And we will set for sentencing and refer to probation. So we've set this for July 18th at 8:30. Along with this file, they'll also have the next file, and you should go down to the 5th floor probation department. I don't know if they'll interview there or set up a time to answer any questions. What they're going to do is develop a report for me, and then on July 18th, we'll see what options are available to us. All right, sir?
Okay.
Anything else for the record in 23-00303 on this file, Ms. Wilson?
Not in this file, Your Honor.
Ms. Robinson?
No, Your Honor.
All right. You're all set on this file, and then we're going to address the other two files that we have, which were already indicated in the plea offer, except for which one exactly are we using? And that was,
I think maybe the most recent one.
all right,
I think there's a 21 and a 22
22.
file.
Is that a fair statement, Ms. Robinson?
Yes,
That
Your
he'll
Honor.
be pleading his charge to the 22 and the 21 is to be dismissed.
Correct.
All right. So similarly, in this case, the document would indicate that this is punishable by 93 days in jail and or $500. You understand that, sir?
Yes.
And this is a misdemeanor, so I'll walk you through your rights again in this case, okay? You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have any witnesses appear at trial, to question any witnesses that are brought against you. You're once again represented by Attorney Aaron Robinson. She would be present to cross-examine any witnesses or contest any charges brought by you by the people of the state of Michigan. You understand that, sir?
Yes.
You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim. The plea was a result of any promises other than what's been stated on the record in the plea agreement, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it your intent today to plead to file 22-03338, the domestic violence in this file?
Yes.
All right. I'm going to bring your attention back. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm gonna bring your attention back to September 2nd of 2022 at the offense location of 1815 Bailey, Apartment 8, City of Lansing, Ingham County. Were you present on September 2nd, 2022 at that Bailey apartment address in the city of Lansing?
Yes.
And who is Latria Macklin Allen to you?
The mother of my daughter.
Okay. So you have a child in common. All right. So you are pleading to offensively touching Miss Allen and not in self-defense. Why don't you tell me what you did that wasn't in self-defense, that was an offensive touching?
That was 2 years ago now, Your Honor. I'm not completely sure.
Oh, all right, Miss.
I can.
Oh, sorry.
No, you're okay.
Yeah.
Wrong answer.
No, it was 2 years ago. So
Yeah, I'll pull it up and I can answer.
She might refresh your memory.
Okay, on September 2nd of 2022, you were at the address of 1815 Bailey Street, Apartment 8 in the city of Lansing, County of Bingham, State of Michigan.
Yes.
All right, and you said that you were there with Latria Macklin Allen, who is the mother of your child?
Yes.
And looks like you guys got into an argument that day, correct?
Yes.
And during that time, it looks like you pushed Ms. Allen to the ground, correct?
Yes.
And when you pushed her to the ground, that wasn't in self-defense? You didn't do it because
No.
she was hitting you? No.
Anything towards the factual basis, Ms. Wilson?
Half of the people.
I find the factual basis to the offensive touching for pushing and not done in self-defense to be knowing, voluntarily, and accurately made. We will also set this for the same sentence date. What date was that?
July 18th.
July 18th at 8:30. So this will be another part of the fact pattern and that you'll go downstairs with for both of the files in order for them to do a report for me, all right?
Okay.
All right. Refer to probation and we'll see what options are available to us on July 18th. And then once we've officially sensed that I have that the other file is dismissed for the plea agreement. Is that correct?
I have a nollie signed already, if we
All
want to
right.
just do it today.
And there was a PA 53 violation. Where else? You'll
We'll
leave
dismiss
with
that
this
as well,
one.
yep.
And write that in so it's not. All right, and I will take the dismissal pursuant to the plea agreement. Thank you. All right, so Mr. Wilson, on the pending misdemeanor and the use of cocaine, we'll see on July 18th at 8:30. Go down to probation and answer any questions candidly, okay, sir?
Yes, sir.
All right, anything else for the record in the preliminary examination or any of the misdemeanor files, Ms. Wilson?
Half of the people, thank you.
Ms. Robinson?
Oh, Your Honor.
All right, you're all set.
Thank you.
We'll see you on that date. Stanley, did we bring up?
Is Mr. Smith here?
It looks like I have an order for fingerprints. That has to be done by now, I would
I
think.
sent it over to county last night again, because it still had not been done, so I'm not sure what's.
If not, I'm sure they can do it. when
All
we
right,
see
the
them
indication is
downstairs.
he's been
I did
fingerprinted.
it the day that I was arraigned, actually here at City Hall.
Okay.
Well, he's got it, yeah, because he's got another case that
Yeah,
has a
so he's
probable.
probably been fingerprinted on the other one. I don't know about this one.
I don't know.
The day I got arraigned, I got a fingerprint on this one. They had me go down to City Hall.
Oh, on the rain on this case.
Yes.
They had you go down to LPD to do fingerprints. Okay,
All
so they
right.
should be somewhere.
Yeah, they should be somewhere. All right. So we're on the record in docket 24-01087. That's people of the state of Michigan versus Chaz Smith. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Donald.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Chas Smith, who is currently standing to my right.
And sir, you are Chaz Smith, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a waiver of the 21 days today. As just mentioned, Mr. Smith has another file that was recently issued, and he's got some other stuff going on in other counties. So he wants to take some time to consider what impact this might have on him before he makes any decisions on this file.
And is that a fair statement, Ms. Donald?
Your Honor, yes, there is an offer to keep this as a misdemeanor. And he did get arraigned on another charge just a couple of days ago that's set for PCC. One of our concerns, though, is that he has an existing city case, and that new possession case, they got assigned to, they're with Judge Buchanan. And then he has this case with you. And I was wondering if if we needed to consolidate it with Buchanan or anything, because she had the cases before. I was just gonna bring that up because.
I don't know. I'm willing to entertain any resolution or, you
Yeah.
know.
I mean,
That's the thing, is the other cases with Buchanan.
it's with Buchanan I think the only way to consolidate with them would be with a joinder motion, and I don't think there's a basis for joinder here. So I think we're kind of stuck with two different courtrooms, but since these are both felony files, this will be an office-wide decision on any offers that are made. So there will be a consensus as to both files.
But so, yeah, if you get the numbers for the other files, we can make it a part of the resolution that whatever we do, we'll even pull those files,
Yep.
if, you know, so. But as of today, in order to further investigate what's out there and for global resolution, Ms. Donnelly, Mr. Smith is requesting a waiver of the 21-day rule, just so we can get everything together.
Yes, Your Honor.
All right. May I inquire your client of his waiver of the 21 days?
Yes.
Mr. Smith, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Sarah Donnelly, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish to waive your right to a prelim within that 21-day period, just so we could get all the files together and take a look at a global resolution. You wouldn't be waiving your right to a prelim in general, just to have it within that 21-day period. Is it your wish today to waive your right to a prelim within that 21-day period?
Yes, Your Honor.
All right, thank you. So I'm going to find that the waiver of the 21-day rule is knowing, voluntarily, and accurately made. And we will reset this for prelim and then give you the opportunity to discuss the other cases, just to get the numbers on the other cases. And we'll reset for.
I'm gonna schedule it with Judge Buchanan's felony file, and I will try to figure this out. So May 30th at 9:30.
So it's May 30th at 9:30 in front of Judge Buchanan.
No, this will be in front of us.
Okay.
They'll both be at the same time. So if there's something that
All
we
right,
can
perfect.
consolidate between
Right.
the two judges, we have that opportunity.
Right. So May 30th at 9:30, both files will be set, and then we can address it at that time. Anything else for the record in 24-01087, Ms. Wilson?
Just that the people also waive the 21 days, just for clarification.
Right, thank you. So the people also waive their right to a prelim within 21 days. Anything else for the record, Ms. Donnelly?
No, Your Honor, thank you.
All right, Mr. Smith, we'll see you on May 30th on that date. Thank you for your appearance today.
Thank you, Your Honor.
And then Nathaniel, can we bring up DZIC when you're down there?
Yeah, that was the PCC for the. You're gonna be by video. Yeah.
Which one is that? Which are you having?
Edward DZIC or
DZIC?
Zick? Do we want to do? I believe we're ready. I'm Mr. Ronald Palmetier.
Palmetier. All right, so we're on the record in docket 24-01220. That's people of the state of Michigan versus Ronald Palmetier. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
Yes, and good morning, Your Honor. Stephen Milks on behalf of Mr. Palmetier. Mr. Palmetier, unfortunately, is not here at this time. I will note to the court that he was released, I think it was earlier this week or late last week, Your Honor. We did have a conversation with him when he was still in jail. Myself and our social worker, Ms. Bingham, have both made several attempts to try to contact him. Unfortunately, we're not able to get a hold of him at this time. Additionally, Your Honor, I anticipate people requesting a bench warrant in 48 hours. I would note that myself, our social worker, we've got some serious concerns regarding his mental health. I don't even think this is a thing, but if there's something to indicate possible PRT needs, I don't think that's anything that can really be done, but I'll leave it at that, Your Honor. Thank you.
All right, thank you. Ms. Wilson.
Thank you, Your Honor. Mr. Mills is correct that we would be requesting a bench warrant with a 48-hour hold. And I have been in contact with Mr. Mills about his concerns with Mr. Palmetier's mental health. I don't think there's a way to include a PRT in a bench warrant.
I don't think so.
If police pick him up and they feel that's necessary, that's fine. And we can address whatever needs to be addressed at a later date.
My only suggestion is maybe get the packet ready. You know, if that's where we're going, it's an easier process if that. Based on the representations of council, this was scheduled for 9 o'clock. It's now 10:38.
Actually, Your Honor, I'm sorry. May we approach?
Sure. All right, so this was scheduled for 9:30, for 9 o'clock. It is now 10:38. The court, based on the court's finding that this may be a mental health issue along with other issues out there, I'm going to issue a bench warrant without a 48-hour hold. So bench warrants issued. For the fail to appear for preliminary examination. And then if there is any type of, if Mr. Palmetier does show himself or you have some contact with him, Mr. Milks, we'll be willing to see him just let my office know, okay?
Thank you very much.
Anything else for the record in 24-01-220, Ms. Wilson?
Not for the people.
Mr. Milks?
No, the defense.
All right, thank you.
So Shatori Blackman is already in bench warrant status. We left it today in case she showed up. I don't believe she's here.
All right.
No? Okay.
All right. That was removed.
Oh, was it removed?
Well, I don't have the Blackman file.
I didn't give it to you. We left it in the bench warrant drawer.
All right. You did good or did not?
I did not. I left it in the bench warrant drawer where it was.
All right.
So I don't know if you want to go on the record on that.
Yeah, well, if Mr. Sarks is here, let's put it on the record. I'll let everybody make a record and we can. So we're on the record in docket 22-02260. That is People of the State of Michigan versus Shatori Blackman. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Ms. Blackman. She's not present. Thank you.
This was scheduled for 9:30. It is now 9:41. Based on the representations of counsel, it does appear that Ms. Blackman has failed to appear. I would indicate that there's been a bench warrant already set for Ms. Blackman on another file. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I think she's already in bench warrant status, so I think we should just continue that.
Okay.
I don't know that there's such thing as a double bench warrant, so.
Mr. Sarks.
That's correct, Your Honor.
Right.
We had left this on as a PCC in the event that she did ultimately show up today. She's not appeared. I have not been able to get in contact with her. Thank you, Your Honor.
All right, thank you. So the court will issue a bench warrant for the fail to appear on this date. Anything else for the record in docket 22-02260? I do, first of all, I do not see Ms. Blackman in the Zoom courtroom or the physical courtroom. This was scheduled for 9:30. It's now 10:42. Anything else for the record on this file, Ms. Wilson?
Not for the people.
Mr. Sarnes?
No, you're on.
All right, thank you. Just to make a note of what we did here. Ms. Swan, she's on, we have on Arapahoe, right?
Yes, and he's in custody. And I don't see Miss Wanji here.
Yeah.
Is Solomon gonna be on Polycom? He didn't have an attorney, so we were gonna treat this as a PCC.
He is not in custody.
He's not in
I'm
custody.
here, I'm right here. Solomon is here.
I was gonna say, he contacted the clerk's office and said he was on his way.
Okay.
All right. So Mr. Solomon's here.
But we do not have any appearance from him.
Did you want to put Solomon on the record?
Yeah, we can do Solomon, sorry.
No worries.
I had to call from a witness.
I can't remember. This is Mr. Palmer or Mr. Shaw too?
Yeah, we already did him.
We already did.
Yeah.
That's what I needed to know. All right, Mr. Solomon, you can come up here. So we're on the record in docket 24-01050. That is people of the state of Michigan versus Raphael Solomon. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And sir, you are Raphael Solomon, is that correct?
Yes, sir.
And you are not represented by counsel today, is that correct?
No, sir.
This is the time set for a preliminary examination. I have a note indicating from Judge Simmons that there was an intent to retain Attorney David Carter, but it did not happen yet. That this was to be treated as a PCC. And then Mr. Solomon may appear otherwise, but he's here in person. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I have no appearance for anybody for Mr. Solomon yet. Given the nature of the charges, I think it's probably prudent for us to adjourn for good cause. I had already called off my witnesses since we were going to treat this as a PCC. So I think we should adjourn this for good cause in order to give him time to retain counsel.
All right, so Mr. Solomon, you understand, you were declined the public defender's office at arraignment. And at the last time, there was an intent to get Attorney David Carter.
Yes, sir.
I do think these are serious offenses, all right? So you should have somebody in your corner to legally represent you in this matter.
Correct.
And that's your intent at this time?
Yes, but I was gonna go with the public defender for now.
All right, you've declined their court appointed, so you're gonna have to make contact with them or find a way to fill out a financial application.
Okay.
I don't know if that can be done now, or if I can provide you with.
We have several public defenders in the courtroom today. I don't know if one of them is available to take it in.
Mr. Milks is raising his hand. So Mr. Solomon, what I'm gonna do is, Mr. Milks has graciously indicated that he will take your financial application in order to make application for a court-appointed attorney, all right?
Right.
If that doesn't work out, we're gonna adjourn this out so that you have an attorney for the next date. We're treating it as a probable cause conference.
Okay.
Because if you don't have an attorney at that time, then you're just running out of time, all right? This is 3 counts of a life offense.
Right.
So you definitely need somebody in your court.
Right.
All right. So I'm gonna find, for no attorney being here, I'm gonna find good cause to adjourn. I'm gonna indicate that you're making application to the public defender's office.
Well, I talked to Dave and, Dave Carter, and he was saying that he was going on vacation for 2 weeks or something.
You're running out of time.
And
Okay.
Mr. Carter's not a part of the public defender's office,
I know, but
so.
So if you were gonna retain Mr. Carter, he's got to file an appearance for you, and you don't have any appearance filed for you.
Right, I understand that.
Right.
I
And so,
understand.
I'm just telling you, you're running out of time. You know, we don't continue to adjourn things for your schedule so that Mr. Carter is or is not on vacation.
Right, right.
All right. I mean, that's not how it works. So I'm adjourning it this one time because you don't have a lawyer
Okay,
today.
right.
I think if you're either gonna make their financial application or you're not. And if you're not, then you should, if Mr. Carter's not available, you should seek a representation elsewhere, okay? So I'm indicating that you're making application to the Public Defender's Office. I do find this is good cause to adjourn for lack of an attorney, and we will reset the prelim. For
Do you want it prelim or PCC?
PCC, that's, yeah,
Would you like the corresponding prelim as well?
yes.
So the PCC would be on May 31st at 8:30,
May 31st at 8:30.
and then the exam would be on June 7th at 9.
So we have the PCC is once again set for May 31st at 8:30. The preliminary examination is set for June 7th at 9. You'll get notice of that from the court officer for both those dates. Mr. Milks will talk to you about making application if that's available. If not for that May 31st date, somebody should file an appearance to get discovery for that, okay?
I will have a lawyer.
All right,
Present.
all right.
Not a problem. I have a lawyer.
All right, so this is adjourned for good cause to May 31st at 8:30 for the PCC. Anything else for the record in 24-01050, Ms. Wilson?
Not for the people.
Mr. Solomon, do you have any questions of me?
No, sir.
Right, you're gonna get written notice, you should be all set, okay?
Okay, thank you.
Mr. Milks is right behind you if you wish to talk to him.
Yes.
Something's going on with that. All right, so we're on the record in docket 24-00890. That is people of the state of Michigan versus Elijah Araujo. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wanji.
Melanie Wanji for Mr. Awu.
And sir, you are Elijah, and correct my pronunciation, Araujo?
Yes, Your Honor.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a waiver of the preliminary exam, with the understanding that at pretrial and circuit court, the people would have no objection to HIDA status should the defendant be eligible.
So there's at least that indication has been placed on the record, and that's part of the negotiations that are continuing.
That is correct.
And that's a fair statement, Ms. Wanji?
It is, Your Honor.
May I inquire of your client of his unconditional waiver of the prelim?
Yes, Your Honor.
All right. Mr. Araujo, you understand that you have a right to a preliminary examination today. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Melanie Wanji, and she would be present to cross-examine any witness, contest any charges brought against you by the people of the state of Michigan. That is my understanding. It is your wish today to waive your right to this preliminary examination, this probable cause hearing, have negotiations continue in circuit court where this case will proceed to trial. Is it your wish or intent today to waive your right to preliminary examination?
Yes, Your Honor.
And the people are also waiving their right to preliminary examination?
The people unconditionally waive their
All
right.
right. I find the waiver of the preliminary examination be knowing, voluntarily, and accurately made, with negotiations to continue and an offer to be placed on the record. And I will have the parties sign the document, the bind over documentation. Thank you, Ms. Wilson. I'm in possession of the bind over documentation of 24-00890. The examination was waived on today's date, May 16th, 2024. Anything else to come to the court's attention before I sign the bind over documentation? Ms. Wilson.
Half of the people.
Ms. Wanji.
Nothing, Your Honor. Thank you.
All right, Mr. Rajo, your time in district court is done now. You'll get your next date in circuit court from attorney Ms. Wanji. That'll be an arraignment date. We don't do that here in district court anymore. I'll probably be in the next couple of weeks. All right, sir?
Thank you.
All right. I'll sign the bind over documentation, and the party should be all set. Thank you for your appearance today. So the Tyler Fisher.
Yeah.
Is Jen Love doing Chelsea's?
That's my understanding. She is.
She is?
Yep.
I wonder, because I saw her twice today and
Yep.
hadn't seen her in a long time.
Yep. Melanie's been moved over to drugs and Jen's in pig runs now.
So so is Melanie part of Tri-County now?
Yeah. Mhm.
It's good to hear.
Andy. Yes. Mother's Day was to ask the kids to. No, his mom. Tia.
We had two. Because they're, because you're. So we just. As long as I'm this. It's Mother's Day. It's the person, it's good, so there's the person. Ours is not. Ours is the
Second Sunday night. I know. Well, that was nice to you.
Yeah, it was fun. Right, so we're on the record in docket 24-01211. That is People of the State of Michigan versus Tyler Fisher. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Fisher. Mr. Fisher's present. He's at council table. He's staying to my right.
And sir, you are Tyler Fisher, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness in this matter did not appear today. She was subpoenaed. Our office has attempted to make contact with her, but we have not been able to. We are not able to proceed on this matter without her. I expect a motion from the defense.
Mr. Sarts.
Thank you, Your Honor. At this time, the defense would move to dismiss. Is prepared and able to proceed today. If the people are unable to meet their burden and unable to proceed, the defense requests dismissal at this time. I've explained to Mr. Fisher that this would be a dismissal without prejudice. He understands that, but still at this point, I would request a dismissal. Thank you.
Thank you. Based on the complaining victim failing to appear after some contact and a subpoena was sent by the prosecutor's office, and people are unable to proceed today, this is dismissal without prejudice. Mr. Sarts has indicated. That means that people could reissue if they choose to. But for our purposes today, the case is dismissed. All right, sir. All right, I will sign the order to that effect based on the representations of counsel. Oh, there were multiple. And I'll sign the Nolly Pros for 24-0211. Mr. Fisher, you should be all set. Anything else for the record in 24-01211, Ms. Wilson?
Half of the people.
Mr. Sarts.
Nothing further, Your Honor. Thank
You're all
you.
set. Thank you for your appearance today.
Thank you.
1316. That's people of the state of Michigan versus Vincent Holmes. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson, good people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Mr. Holmes. Mr. Holmes is present at council table. He's standing at my right.
So you're Vincent Holmes, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. As we've discussed a bit before at the bench, I did have a witness here that, or she wasn't here, but she called me, said she was on her way, but that she had gotten herself lost. I know that she started work at 11, so she is not currently here. I did have an officer on standby in order to be able to start the exam today, but after discussion with defense counsel, I think we're in agreement that we should adjourn in order to do everything together, and then also potentially to look into a possible conflict issue that may exist.
Right. That's your understanding, Mr. Sartz, and just for the record, the council did indicate that they're anticipating, as good lawyers do, there may be a potential conflict. And then, Mr. Sartz, you were aware that the prelim may be started today, and then we talked a little bit about that. You can make a record.
Thank you, Your Honor. Respectfully, yeah, I believe there would be good cause here to adjourn the proceedings. Certainly, Mr. Holmes' preference would be dismissal, but it's well within the purview of the prosecutor to start a preliminary examination within the 21 days. That satisfies that. Even if they're unable to finish it, I don't see a benefit to starting the exam, especially if there is a significant potential conflict with our office to a point where we need to get Mr. Holmes' new counsel. I don't anticipate that's going to be the issue here, but that's not my call. It's up to Chief Public Defender, Mr. Watson, and or Chief Deputy Cornish, Your Honor. So that's certainly something I will look into on my end. And as for the witness being available, this is a case where they would potentially need her to testify because this is not a domestic situation, Your Honor. So I would anticipate the prosecutor would also argue for good cause on those grounds as well. Respectfully, I've informed Mr. Holmes of this issue in terms of, and now Mr. Holmes has had the opportunity to hear this conversation on the record about the reasons. I just would respectfully request the court consider reducing his bond in light of the necessity for an adjournment at this time. Thank you.
All right. So first of all, I do find good cause to adjourn the proceeding based on the non-appearance of one of the victims who indicated that we could get it started. They indicate there was contact with them, so it's not a person who's refusing to be here. It's a person who can't be here at this time. I think that's good cause to adjourn it. So I will not, Mr. Holmes, not be waiving any rights in this matter. We find good cause to adjourn it at the next most recent date we have available, sufficing for subpoenas. So I would think 2 weeks out. All right, so, and then the issue, so we have reset this for May 30th, 2024, which is 2 weeks out to have subpoenas go out. And we'll readdress, the victim should be here at that time in order to testify. And then Mr. Holmes is asking for reduction in bond at this time. Ms. Wilson, your response, and then anything further on bond concerning this matter, but I'll allow Ms. Wilson to respond to the initial request.
Thank you, Your Honor. The defendant currently has a 15,000 10% bond. He does have a fairly extensive criminal history. My biggest concern here is that at the time of the offense, he was living in a duplex that is with the residence that the witness and victims were residing in. So I think that if there's going to be a reduction in bond, we need an address that he's going to be staying at and possibly a GPS tether with an exclusion zone.
And that was an important, there was no current address. So they did do a GPS with the 2000, that was a part of the original pretrial condition. No contact order and then an exclusion zone. But I don't see an address. There was no current address. Mr. Sarks.
Thank you, Your Honor. Mr. Holmes, do you have an address currently available?
Yeah,
You can tell the
it's
court.
right here on this paper, 1725 Belfort, Rochester, Michigan.
It's out of county, Your Honor, but it is a good address for him.
1725 and
Bedford Square. It's right on
Bedford
the
Square, apartment 206.
It's right on the complaint, Your Honor.
There was a request, there was a pretrial report done on the matter that would indication that a PR bond is not appropriate. I will reduce bond though, because I believe that that bond may be reduced at this time. So I'll reduce bond to 7,500, 10%. Continue, if you're able to make bond, there's the GPS, zone notification, and victim notification, depending on which one is they're amenable to. There's no contact with the victim, with either victim, Dominique Good or DeAnthony Townsend in this matter. And then all the prior pretrial conditions of no use of alcohol, drugs, no assaultive behavior, no possession of firearm, and report to pretrial services within 48 hours. I don't know what is the PREM?
That's the premises.
No premises was also ordered. That all stays in place. The address you've indicated for the record is the address of 1725 Bedford Square apartment 206. That should be confirmed. Okay, that there should be some confirmation of the address in order to make sure that that is where the defendant is going to be located. I'm only doing that because that was not given. That was the address given at arraignment. Okay, yeah, it says it was confirmed. So that location should be confirmed. That was the given address to the arraigning judge, and I will set bond at 7,500, 10%. With the continuing GPS and no contact with the victims. And then this has been reset for May 30th at May 30th, 2024. What time do we have? 9:30. At 9:30. And that should give you sufficient time to get the subpoenas out, Ms. Wilson.
Yes, it should.
All right. Anything else for the record in 24-01316, Ms. Wilson?
Not for the people.
Mr. Sarks.
Nothing further.
All right, you're all set, Mr. Holmes. Thank you for your appearance.
Thank you.
And Mr. Sarks, you're here this afternoon, not a few.
Yes, Your Honor. Yeah. Well, with Mr. Garza, I don't think.
All right.
He allegedly cut off his tether, so.
All right.
Oh, fun.
All right. So
yeah, I'm not too optimistic.
you're good, but you're not that good, Mr. Sarks. All right. And then Abby, you're here on Mondays?
Yes.
Okay. So you're gonna get an email from
Yeah, I
Lindsay
got it.
Yeah, so-
Yeah,
to meet up on all that. Because if that's kind of if this is my thinking on that.
yeah,
If we haven't decided, if we haven't come to a resolution on that, we're not calling in a jury for Monday.
right, yeah. Mhm.
Because, and right now, I don't think there's come to a resolution of that. Just the look on your face would tell me that that hasn't come to a resolution of that.
Yeah.
So there's no reason to bring in a jury when we haven't
Right.
worked it out. Yep.
And I plan on filing a response to both of them at some point.
Yeah,
I don't know if it's gonna be today because.
It
of our
doesn't have,
docket,
it
but-
doesn't have to be today, but if you show up and you just showing up and letting me know, like,
Yeah.
we're not done fighting about
Yeah.
this, that answers my question.
Yeah.
Okay.
So I don't know what this is.
Moore.
Emil Moore.
Mhm.
Right, we're so on the record in docket 24-01094. That's people of the state of Michigan versus Emil Moore. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarks.
Good afternoon, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Moore. He's present at council table. He's standing to my right.
And sir, you are Emil Moore, is that correct? Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. There was another felony file that was recently authorized here. I believe we're going to be requesting an adjournment. It was my understanding that it was supposed to be sworn to today. I have not received confirmation about whether or not it has been, but it should be sometime soon, and we're hoping to address them together.
All right. So it's a request for an adjournment based on global resolution, or at least consolidating or getting both files together. Was this a good cause adjournment last time, or what, was there a waiver? Because I have requested an adjournment for good cause, and then I have a waiver of the 21-day rule.
I feel like we have waived at one point, but I can't
I think we
quite
waived it.
recall.
April 26th, we had.
Yeah, so I think we started and then we decided kind of take, so I will grant the adjournment. Is that a fair statement, Mr. Sarts?
Yes, Your Honor. Certainly this needs to be investigated, and further, Mr. Moore's been doing a very good job while he's been out. He's been no issues since he's been out on bond, and he'll certainly make sure that he shows up for his next court date, Your Honor.
All right. I've indicated that the waiver of the 21-day rule happened April 26th, and we will grant the adjournment for reviewing the other file that's just been issued, and we will set this for.
Do we know when it's being sworn to by chance?
Today or tomorrow?
I would hope, I was told either today or by the end of the week,
And then
so
you need a couple weeks for your,
I would say at least 2.
at least 2 weeks.
I have to go through the agreement process.
Okay. Yeah.
June 7th.
June. And then Mr. Sarks, are you, I can't remember what the schedule is. Is June 7th the date for you?
Yes, that's available now, Your Honor.
Okay,
Yes.
June 7th
At 9:30.
at 9:30. I know you have a busy trial schedule also. All right, so we have reset this for June 7th at 9:30, and we will await the other file. Anything else for the record? And 24-01094, Ms. Wilson.
Not for the people.
Mr. Sarks.
Nothing further, Your
All right,
Honor.
Mr. Moore, you can get, you'll get notice from my court officer. Thank you for your appearance today.
Hey, here, 1 second.
And then I think we're ready on Garza whenever the court is.
All right. It's Lorenzo.
Mhm. Your Sarts is just double checking.
Just
Yep.
be diligent. I wish all attorneys were that diligent. All right, so we're on the record in docket 24-01091. That is people of the state of Michigan versus Lorenzo Garza. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarts.
Good afternoon, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Lorenzo Garza.
This is the time set up for a preliminary examination and a PA 53 contempt. This is scheduled for 1:30. It is now 1:45. My understanding is from representations that there was some concern that Mr. Garza would be here today. I know that Mr. Sarts has been checking the hallway. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Just a few minutes ago, I did receive confirmation from JSG that Mr. Garza has cut his tether. I just forwarded that to Mr. Sarts. He seemed to have known about it before I did, though. So I would be requesting an immediate bench warrant and bond forfeiture.
And Mr. Sarts.
Thank you, Your Honor. Yeah, back on May 9th, I received a report from pretrial services alerting that there were allegations that Mr. Garza had something going on with his tether. There was a memorandum that was submitted. My apologies, I believe the prosecutor was supposed to have been CC'd on it, but
Sometimes they forget.
sometimes they forget. But regardless, yeah, I had been alerted back on May 9th. around that date that there might be this issue. So I've checked the hall, Your Honor. Mr. Garza does not appear to be present, and I have not had any contact with him recently, Your Honor. Thank you.
All right. So at this time, I'll issue a bench warrant for Mr. Garza. And there's also PA 53. I'll indicate that he was bench warranted on the underlying file 24 for the failure to appear, and it would have been that doesn't come as a surprise since the tether was cut on a previous date. Anything else for the record? And so I'll issue a bench warrant for the defendant for failure to appear today. Anything else for the record in 24-01091, Ms. Wilson?
Not for the people.
Mr. Sarks.
I'll just stick around for another 15 minutes.
All right.
I don't expect he'll be here, Your Honor. Thank you.
All right. All right. Thank you.
Your Honor, if I could just have a moment to release my officers.
Sure.
Thank you.
I'll hold off on that till. And Ms. Wanji?
Yep, I believe we're ready on Mr. Rose.
All right. All right, Ms. Wanji, we'll call your case. We're on the record in docket 24-00844. That is People of the State of Michigan versus David Roseberg. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wanji.
Melanie Wanji for Mr. Elizabeth.
And sir, you are David Roseberg, is that correct?
Yes, sir.
Right, thank you. This is the time set for a preliminary examination day. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I do have my officer here today. I am ready to start the exam.
All right. So are there any preliminary matters to come to the court's attention from the people in this matter?
I'm assuming sequestration of witnesses.
All right, Ms. Wanji, anything to come to the court's attention before we get started?
No, just the witness.
All right, so bring my attention if anybody comes anybody's in the courtroom or comes into the courtroom and they shouldn't be present during another witness's testimony. We will exclude them pursuant to the sequestration order. I'm probably going to turn off that fan then, since if we're going to take testimony. And Ms. Wilson, you may call your first witness.
Thank you, Your Honor. The people would call Officer Singer Candle.
Yeah, Officer Candle, you stand right in front of me and please state your first name and last name and spell them both for the record.
First name is Sagar, last name is Kendo, spelled Sagar, last name is Kende.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, go ahead, have a seat and just project as best you can because I don't know how the mics are working today, okay?
Absolutely.
And we turn off the fan. Ms. Wilson, you may proceed when you're ready.
Thank you, Your Honor. Officer Kendall, are you currently employed?
Yes, ma'am.
And where are you employed?
I'm employed with the City of Lansing Police Department.
What are your general duties?
My general duties is to respond to 911 call for service and basically acting as a patrol officer for the Lansing Police Department.
And were you working as a police officer on March 24th of 2024?
I was.
And how were you dressed?
I was dressed that day in full patrol uniform, so I had my ballistic vest with my badge that identified myself as a sworn patrol officer for Lansing Police Department.
Okay, and on that March 24th date, were you dispatched to a 519 North King Boulevard?
I was.
And is that in Lansing?
It is.
Ingham?
Yes, ma'am.
Michigan?
Yep.
And what were you dispatched for?
I was dispatched to assist other officers that were there for a welfare check of a female. Basically, the call information was that female was inside, basically held against her will, and the caller had requested us to check her welfare.
And when you got to that location, what happened? What happened?
So I got there. There are two other officers that were already on scene. They had obtained a phone number for the victim, and the officers there had asked our central dispatch to ping the phone, and the phone had pinged in the general area of that 519 King address, and I got there after that was done and helped the other officers out.
Okay, and so when you arrived, you said there were other officers already there.
Correct.
Okay, was there anybody else at that address?
Yes, so once I got there, I talked to the other officers that were there. They had told me that.
Response?
I guess I don't know what the statement would be, so it could be possibly effect on the listener. I don't really know at this point.
Right, so there may be a hearsay response. I'll wait for you to ask additional questions. The objection sustained at this point in time is as to whether I'm going to use it substantively or for another purpose.
Okay, so may the officer respond then?
Yeah, I have to hear a little bit more to know that.
Yeah, I arrived on scene and I spoke with Officer Stover, who was first on scene, and he had advised me that he made contact with someone else in the house, and they had received consent to check like the basement area of the house, but they had not searched the entire house. And they exited. Once I got there and got information about the phone ping, I spoke with the same subject that I talked to earlier and also the homeowner, and obtained consent to go inside the house.
Okay.
So I'm going to use this as something for something other than true.
I think it would be effect on the listener
Right.
to get the subsequent consent.
So the objection for hearsay is not being offered for the truth being offered for something otherwise an effect on the listener, and I'll sustain the objection and allow you proceed as not as substantive at this point.
Thank you, Your Honor. So after you received consent to go into the home, what happened?
While we're in the house, I had spoken with the homeowner who was out of town over the phone, and we had received consent to search the house. While searching the house, in the living room and the kitchen area, there was a room that had two doors, and the male subject who was inside the house told me that there was a storage room that was locked from outside. And the homeowner also told me the same thing, and she had advised that she had the key to that room. But while searching the house, I could hear music playing inside the room, which was odd because I was advised that the key was with the homeowner, it was not there. While I was doing so, I double checked to make sure those doors were locked, which I was told they were, but it was not locked, and there was a TV barricading it. Once I kind of pushed the door open, I could see a male and a female inside. And at this point, we had made several announcements to make sure police presence was known.
And at some point, did those individuals come out of the room?
Yes, ma'am.
Okay.
The male subject was detained and we went inside to check on the female's welfare and she was also removed from the house.
And the male subject that was there, did you get a good look at him?
It did.
And do you see him here today?
I do.
Can you point him out and describe something he's wearing?
He's sitting over there in a white shirt.
Okay. And so you said that he was detained. What happened after that? Oh, I'm sorry.
Any objection to the witness
Record reflect
identifying the defendant for
identification.
purposes of prelim?
If I may, Your Honor, I have a witness here.
All right, so, sir, you're gonna be a witness in this case, so we're gonna have to sequester you. You can't watch another witness testify, according to the attorney.
I didn't know I was gonna be a witness.
Well, now you know. All right, so I'm gonna have you sit in the hallway and await. Okay, thank you. All right, and then any objection to the witness identifying the defendant for preliminary purposes, Ms. Wanji?
No, Your Honor, thank you.
Okay, without objection, the witness has identified the defendant.
Thank you, Your Honor. So after he was detained, what happened?
He was removed from the house and other officers placed him in the backseat of police vehicles. I then made contact with the female victim that was inside the same room.
Okay, and in making contact with her, did you have an opportunity to speak with her?
Yes, ma'am.
Okay, did she inform you or what was her demeanor?
She appeared very hesitant and scared. She had a hard time looking at me in my eyes when I was asking her specific questions about assault. She would look away and she showed sign of fear and didn't want to leave through the front door, so we had to come up with a plan and remove her from the house through the back door, and she didn't want to be in sight of the defendant.
Okay, and where did she go after she was removed?
Once she was removed, we placed her in a police vehicle and took her away from the scene, a couple blocks away, where another officers obtained her full statement.
So you did not obtain her full statement at that time? Okay. Okay. I have no further questions for this witness, Your Honor.
All right, cross-examination, Ms. Wanji.
When you saw her, was she injured?
I did not see any visible injuries on her.
Now, you said that she appeared to be, did you ask her any question at this scene?
I did ask her a few questions.
Okay, did you ask her, whether or not she had, what kind of question do you ask her?
I would have to read my police report for exact questioning, but I know I asked her if she was assaulted and if she was being held against her will.
And what did she told you that she wasn't, correct?
I believe she said not really against her will part.
Okay. You also asked her if she was being held against her will. Is that correct?
Yes, ma'am.
And she said that not really.
Not really, correct.
Yeah. I have no further questions, Your Honor.
Any redirect from the prosecution?
Briefly, Your Honor. When you were asking questions with the woman inside the home, was that while she was still at the home?
Yes, she was still at the home.
Okay, and what was her demeanor while you were asking her those questions?
When I started talking, she was just really panicky and wanted to leave the house. She had a really, like I stated, she had a really hard time making eye contact with me. And when I asked her, I believe I asked her if she was assaulted, and she wouldn't answer that. Her eyes would deflect away, which is a common indicator of domestic victim.
Nothing further at this time, Your Honor.
May this witness be excused from the people?
I have a follow-up question.
May I ask?
How long have you been a police officer?
I've been a police officer for 5 years.
Now, in your line of witness, if someone is lying, the person is not going to look at you also, correct?
That's also correct, yes.
I have no further questions, Your Honor.
Thank you, Ms. Wanji. Any additional questions, Ms. Wilson?
No, Your Honor, thank you.
Any additional questions? You've had your opportunity to cross. May this witness be excused from the people?
You may, Your Honor.
From the defense?
Yes, Your Honor. Thank
All
you.
right. Thank you for your appearance today. You're excused. Any additional witnesses today, Ms. Wilson?
Not today, Your Honor. At this time, the people would be requesting a continuance to obtain the necessary witnesses.
Okay. So the request for an adjournment after the hearing has already started. Ms. Wanji, anything in regards to the request for the adjournment?
I wish we had have known that, but that, so that we don't diffuse the testimony on on Zoom.
I thought that Officer Kendall had taken the subsequent statement, so that is partially on me, but at this
We're
point.
not on, I don't know if we're on Zoom.
That's-
We're on Zoom, but
So,
Yeah.
so at this point, I don't have the other witness that I need
Right.
here. So
So-
I am requesting a continuance.
right. So respond to the request for an adjournment, and Ms. Wanji, your indication was that was not known to you at the time. Any other response to the request for an adjournment?
No, you're not. It was just my concern was just the diffusion since we have a sequestration of
Right.
witnesses.
We have a sequestration in regards to the courtroom. Towards the live stream, it's a little different. So so I wait for the parties to introduce that directly because we kind of lose control. I am more than willing to turn it off, but right now it's on. The live stream is on. I would say that we have started the hearing. There's been one witness who's testified. We will adjourn the hearing based on additional witnesses coming forward. So we will adjourn. And about how long are we looking at?
I would request 2 weeks.
2 weeks? Or in the whereabouts?
Maybe June 7th at 1:30.
June 7th at 1:30.
I have just 1 minute, Your Honor.
Okay. Okay, June 7th at 1:30 for additional testimony concerning this prelim that's already started. So anything else on the recontinuation on docket 24-00844, once we've started the prelim, Ms. Wilson?
Not for the people, thank you.
Ms. Wunsch?
Nothing other thing.
All right, I'll see everybody back here on June 7th at 1:30. I know something.
I'm sorry, yeah.
I didn't think so.
I didn't either, yeah. I think that's all. For us, at
I
least.
think that's all for criminals.
Looks like you've still
Yeah,
got stuff to do.
I've still got stuff to do, but. And then Mr. Levine, Mr. Hitchcock, you're here for Swiss Stack Levine.
Good afternoon, Your Honor. Yes, I am.
All right, and then Ms. Butler, you're here for that same file, is that correct?
Yes.
All right. All right, so and this is a motion to set aside, I believe a motion to set aside the conviction. I don't know if this would, but I always give the opportunity. Did the parties want to speak about anything in a breakout room before we call the case? Mr. Hitchcock?
I appreciate the opportunity, Your Honor, but I don't believe so. I had a chance to confer with my client this morning, and there's no interest in stipulating to the defendant's motion.
All right.
So,
all right, let's go ahead and call the case. Then we're on the record in docket 22-00063. That is Huntertown Properties versus Naisha Butler. Will the parties please introduce themselves for the record? Mr. Hitchcock.
good afternoon, Your Honor. Clifton Hitchcock, Swiss Stack Levine, on behalf of the plaintiff, Huntertown Properties LLC.
And ma'am, you are Naisha Butler, is that correct?
Yes, I am.
All right, and you can hear me all right, Ms. Butler?
Yes, I can.
All right, this is a time set for a motion. This is a motion to set aside the previously, this was a motion to set aside, and then I think that at the actual order, at the actual motion, there was a fail to appear. And so you submitted an order denying motion to set aside. Is that correct, Mr. Hitchcock?
That's right, Your Honor.
All right. And so you've refiled the motion to set aside the conviction, Ms. Butler. I can read your motion into the record, and then you could have the opportunity to supplement it in any way. All right, ma'am?
Okay.
It is alleged that on May 5th, 2024, that you filed the following motion to set aside the conviction. When I first got in the apartment, I just turned 18 years old and I was working at FedEx. I thought I was ready and responsible enough to have an apartment, but I see that I wasn't. Ended up losing my job and had a hard time finding another one. Ended up moving back with my mom about a year ago. I had my son. I had time to reevaluate my life and goals. Wanted more for myself and my son since I had time to reevaluate my life, that I didn't want to keep moving from place to place, that I needed to find a job that I would help to pay for rent, etc. Please consider removing, consider REMND removing this eviction of my rental history so I can provide a place for me and my son to stay. I was scheduled a Zoom meeting at 2:30. That is the April 22nd hearing. I missed that, didn't see the email until the next day. Please, would you consider accepting a new motion, rescheduling a new date and Zoom time? If rescheduling, could it be 1 p.m. Michigan time? And that would be 2 p.m. Tennessee time. That is the nature of your motion, Ms. Butler.
Yes.
All right, did you want to supplement that in any way?
No, just that I wanted to get it removed so I can provide a place for me and my son. I am also working at the time. I am with General Motors, been with them for 2 months now. Still staying with my mom, but just wondering if it could be removed so I can have a place for me and my son.
All right, thank you. Response, Mr. Hitchcock.
Your Honor, my client objects to this motion. As Your Honor noted, this order of eviction was issued over 2 years ago. And, you know, in that time, the defendant has not offered or paid any money whatsoever to my client. And in fact, currently still has an outstanding balance of $11,925.35. So while I understand she may want this removed from the record for purposes of future rental applications, et cetera, I don't believe that the defendant has shown good cause to have the order of eviction set aside, and therefore plaintiff objects to the request and requests that Your Honor enter an order denying defendant's motion, and that any escrow that may have been paid by the defendant, and I don't know if there is any, be released to my client as well.
All right. Well, in my understanding, it's a twofold test in regards to explaining the fail to appear, which initially started in the February 23rd, 22. There was an initial default. Then on April 26th, 2024, there was a motion to reconsider And that was through non-appearance for the witness says that they got it the day after that. But that doesn't seem to be any meritorious claim in regards to the outstanding debt still being owed. So I'm going to deny the motion to set the order aside. So I'll deny the motion to set aside order. Any escrow would go to the plaintiff if there is, if any, at this time. And then, so I'm denying the motion. Mr. Hitchcock, I don't know if you want another order to set aside, another order denying the motion to consider. I signed the first one on April 23rd, but it has a different date than today's motion date.
Yes.
You may want to just follow that up.
I do. I have another prepared order denying defendant's motion with today's date on it. And how may I submit that to the court?
By e-file?
Yeah, it's an e-file. I'm sorry. Yes,
Yeah,
I will.
by
I will
e-file.
submit. I'll submit that right away, Your Honor.
All right. So Ms. Butler, your order, your request to set aside the eviction has been denied based on this is the second time. The first time was out of 2022, and then you failed to appear for the original motion of April 22nd. I know you've indicated reasons why, but I do not find that they meet the standard to set aside the eviction, and therefore I'm denying your motion. All right, ma'am?
Okay.
Anything else for the record in 220063, Mr. Hitchcock, and you'll follow that up with an order. Is that correct?
That's correct, Your Honor. Nothing further for me.
You're
Thank
all
you
set,
very
Ms.
much.
Butler. Thank you for your appearance today.
Thank you.
Yeah. Have a good one.
And I have Mr. Mr. Joseph, you're here. Are you here on the Waverly Place case, or are you here on DWL Indus Realty case?
I'm here on the Waverly case.
All right, you're here on the waiver. That's the following case. And then with sir on the I Wiltsey moniker, would you please identify yourself?
My name is Lori Wiltsey and I work for Waverly Park Apartments.
Okay, you work for Waverly. Okay,
She's
so
our
that's your
witness.
client, Mr. Joseph,
Yeah,
is
yeah.
that
If
correct?
we need one, she's our witness.
Yes.
All right. All right, stand by. I'm going to call your case in a second. I've got a case right before you. All right, sir? All right, so we're back on the record. I do not see a legal representative of DWL Indus Realty.
Was on Zoom. I don't know where he went. He left. He was
What's
on,
that?
I think he was on Zoom.
Was he?
for 15 minutes. I don't know where he went.
Mr. Bragg. I'm not here. I'm just here for your motion. Okay, so so he was here at earlier, and then
That he left. I don't know when he left, but he was on here for a while. Adam said he's no longer on this case.
And Mr. Akanicki's, all right. All right, so we're on the record on this case. This is set for 1:30. It's now 2:15. Mr. Akanicki, I was told was here on Zoom and is not here. This was a motion, this was a motion brought by yourself, Mr. Bragg, in regards to stay the order of eviction. Is that correct? Because you were unable, and so I'll read that into the record, and then you can indicate if you want to supplement it in any way. You were locked out on the day of April 1st. You could not move your property on the date. You were supposed to be before the court on April 8th. I don't see where. I don't see where you got that April 8th date from.
I was supposed to move out by April 8th.
All right. I was supposed to move out by April 8th, also not giving my deposit. All right. So I have all parties appeared. You were to talk to legal services. You're not represented by legal services at this time. Mr. Akanicki's not here. I was here and is not here. So let's do it this way. I will grant your motion, okay? That we resurrect the case. Essentially what you're saying is to set aside the eviction at this point in time.
Yes, sir.
But I'm not going to dismiss the case. I'm just going to I'm going to set it for pretrial.
Yes, sir.
All right. We'll set it for pretrial. Everybody shows up and we'll start the process. I'm going to set it as soon as I can. But I'm going to grant the motion to set aside. I'm going to indicate that defendant appeared. Plaintiff did not appear. And we'll set for new pretrial. On. I think we have to set it. We've already had a pretrial. We've already had a pretrial. Legal services came in. So they've gone through it. We can set it for formal hearing. But we've still got to set it out sometime. All right, so we've set this for formal hearing, okay? You've had the opportunity, legal services was involved in the case. You still have the opportunity to seek your own counsel in this matter, but we've set this for June 5th at 1:30, all right, sir? So June 5th at 1:30, you'll get notice from my court officer. And Mr. Akanicki will be sent notice at DWLS Industry Realty. And you should bring in anything you want the court to consider, anything that you want marked. I should have it tangible like this, okay? Not on video, not on phone or anything. That way the court can consider it and it'll be marked, all right?
Thank you.
All right. Anything else for the record? Do you have any questions of me in 2303-205, Mr. Bragg?
No, sir.
All right, you'll get your notice from my court officer and I'll see you on that date.
Thank you, sir.
Thank you. All right, Mr. Joseph, we're ready to call your case. You're here for Edward Rose,
Yes,
or you're
Judge.
here for Waverly Place, is that correct?
Yes,
And that's Mr. Herman's case, and you're substituting it, or you're covering this case for him, is that correct?
that's correct. Yes.
All right, so we're on the record in docket 24-01556. That is Waverly Place versus Robbie Paxton and Persissi Reed. Will the parties please introduce themselves for the record, and Mr. Reed and from Waverly Place?
Thank you, Judge. Joe Joseph on behalf of the plaintiff.
All right. This was a time set for a motion to set aside a conviction. And if I remember correctly, this was a motion to set aside, and this was filed on yourself, and because of clerical error, the case was dismissed. Is that correct, Mr. Joseph?
Yeah, that's correct, Judge. It's our motion to reinstate.
All right. And at this motion, that motion was set for hearing on, well, the motion set for April 25th. That's the date, the motion. I want to make sure that we have something to indicate that they received some notice on this. Let's see. And they received, Bobby Paxton received notice. See, they received notice for their pretrial conference is set for May 29th. Do you have that? Let me look this up on the computer to see
Judge,
what's going on.
Yeah, the issue with this, I think it has to do with when the court went to my file. There were two different cases, and these cases were being rejected. And there was confusion as to why they were being rejected. And that's not uncommon. I mean, we've had that with quite a few courts when, when launch just happened, and, everyone's doing the best that they can when these things happen, and in conjunction with the court rules changing. So anyway, there might've been two cases. One of them, in this case, was dismissed, thinking it was a duplicate case, I believe. So there still I don't know if the other case is still on or not, but that's what we're trying to figure it out, and it shouldn't be as difficult as it is, but it has apparently eluded us, and this case was dismissed, but it was, like I said, dismissed in error, and there's still a balance currently due, but I don't have a May 29th date.
Yeah. So let me check the computer, see what we have, and then I'll come back in just a second.
Okay.
Right. All right, Mr. Joseph, we had to do some, I say I. I'm still, I'm not exactly sure what happened. It appears that this was that that your office filed a dismissal on the case through some type of, well, error, but it ends up with 1566, and that's what we hear on your dismissal. And I had to print that out because that wasn't scanned. That came from another computer system, but I have Mr. Herman filed a dismissal on April 11th. And so is that why, that's why and we've never had a pretrial on this case.
That's correct. Yeah.
All right. So let's do this. I don't know the status of, I don't know the status of whether they were served, or because I can't find anything that says they were served for this hearing. They failed to appear, but I'm going to grant the motion to set aside the clerical error dismissal. So I'll grant that motion, and then we'll just reset it for a pretrial so that we have a regular pretrial and everything. Because I don't think we've even had a pretrial on this.
That's correct. Yeah, the proof of service regarding their notice that was attached to our motion pursuant to the court rule. So that's how they were served. Looks like that proof of service was dated for the 25th of April.
Okay.
So that should be the last page of the motion, but that's fine. It would be
I don't-
appropriate either way for the pretrial to be reset. And then whatever date the court chooses, I assume we'll just get notice.
And that's my fear if this was, because my last date is April 16th was when the pretrial was initially set, and then it was dismissed. You're right in the middle of this e-file transfer transition. I think when they got your dismissal, they canceled everything out. And so now we've got to reset the pretrial, but that's what I'll do.
Okay.
And that way we can get everybody here. And if they don't show, we've got good notice on it.
Okay, that's perfect. That's fine.
All right, so let's do that. Let me get rid of this. I can't get into. All right, I was having some computer issues myself, but I'm going to indicate that the plaintiff appeared. And the motion D did not appear. Motion to set aside dismissal is granted. Then I'm gonna set it. We've never had a pretrial on this, so I'm gonna set this for pretrial. On
July 24th at 9:30.
July 24th at 9:30. And that, and then we'll just act as if that's a brand new pretrial, so we'll get service sent out and we'll understand if the party, that way, that a decision can be made on service on that date, but I've reset it for pretrial. I don't know the arena behind it, but I've granted the motion to set aside the dismissal and we've reset it for pretrial on July 24th.
Yeah, and is that the first date we have available, July 24th?
That's the first date we have for pretrials, yeah.
All right.
Right now.
Okay.
All right.
All right, very good, Judge. I appreciate it. And we
All
will
right.
see you on the 24th.
All right, you'll follow up with an order to set aside the dismissal based on the motion.
Yeah, we'll file that order with the court.
All right, thank you, Mr. Joseph.
Thanks, Judge. Have a good one.
All right.